abrogation of Article 370. In re. Article 370 of the Constitution. On the 11th of December, a Constitution bench led by Chief Justice D.Y. Chandrachud upheld the central government's revocation of the special status of the erstwhile state of Jammu and Kashmir J&K. Parties challenging the abrogation claimed that the Union broke a constitutional promise made to J&K and breached the internal sovereignty enjoyed by the state per Article 370 of the Indian Constitution. They also contended that the provision was permanent and could not be abrogated after the dissolution of the J&K Constituent Assembly. The Union, on its part, claimed that the provision was temporary and that its abrogation had ensured complete integration of J&K into India. The court agreed with the Union that Article 370 was a temporary provision as indicated by its placement under Part 21. It also upheld the validity of the presidential orders that abrogated Article 370, ruling that it was not a mala fide exercise of power. However, the presidential order amending Article 367 was held to be constitutionally invalid. The court refused to comment on the validity of the reorganization of the state on the ground that the Solicitor General had submitted that statehood would be restored to J&K in due time. Supreme Court Observer reported extensively on 16 days of hearings in the case. Reports of each day of hearings are available on the case page. A summary and matrix of the judgment highlights the view taken by the 5 judges. 2. Plea for marriage equality. Supriyo et Supriya Chakraborty vs. Union of India. On the 17th of October, a constitution bench led by CJI D.Y. Chandrachud rejected a batch of petitions that sought the equal right to marry for sexual minorities. The 5-judge bench unanimously held that there is no fundamental right to marry under the Constitution of India. They held that marriage flowed from social customs and not from law, which meant that a legal framework cannot enforce it as a right. They reasoned that the court cannot recognize it as a right as it would place an obligation on lawmakers to codify an institution that the law did not create. The bench was also looking into whether validity of marriage between queer persons can be found within the Special Marriage Act, 1954 SMA. 4 of the 5 judges held that the purpose of creating the SMA was to facilitate interfaith marriages. It cannot be held unconstitutional for excluding non-heterosexual couples from its fold. They warned that declaring the SMA unconstitutional would take India back to the pre-independence era, where persons of different castes and religions could not marry. Justice S.K. Kaul disagreed, holding that the SMA's initial purpose of interfaith marriage does not justify the exclusion of queer persons from its ambit. 3 of the 5 judges were of the view that queer persons do not have a right to enter into a civil union. They found that it is not within the court's power to recognize the right or to compel Parliament to make a relevant law. CJI Chandrachud and Justice Kaul, in the minority, held that there is a right to civil union. The bench was unanimous in its view that transgender persons in heterosexual relationships have the right to marry under the existing legal framework. SCO's judgment summary explains the 366-page judgment in short. The judgment matrix breaks down what each judge held. 3. Maharashtra political crisis. Desai vs. Principal Secretary, Governor of Maharashtra and Ors. On the 11th of May, a 5-judge bench held that the governor's decision of ordering a floor test to gauge the support to then Chief Minister Uddhav Thackeray was illegal. The reasoning was that the governor of Article 370